everyone. We are the group 16 and this is our topic, the gender inequality in the marriage and criminal laws. So the objectives of this lesson is discuss the presence of gender inequality in marriage and criminal laws. This also tackles the proposed same-sex marriage legislations. At the end of this module, you are expected to understand full gender inequality in marriage and criminal laws, determine the status of gender inequality, and selected provisions of these laws and the access provisions on the proposed same-sex marriage legislation. So, definition of term. What is marriage? A marriage is a special contract of permanent union between a man and a woman that entered into accordance with the law for the establishment of conjugal and family life. So, example here is our mom and dad or our parents that they're legally having together after their marriage. They are they are permanent na mag-uban sa isa ka pamuyo. So, marriage also is a legal compact between two individuals to bind their lives legally. Lives legally. Being a married person or being married is also give sexual relations within the marriage of legitimacy. So, example is if ang duha ka person is legal na sa kaminyoon, they can create their own family. Like for example, their legitimate child or their legitimate children rather, and to be as a part of a family life. So those are example of a marriage. So part na siya sa kaminyoon.
Introduction. Marriage laws in the Philippines are only based on sex and not gender. In the 1987 Philippines Constitution, marriage is stated as an inviolable social institution, is the foundation of the family and shall be protected by the state. Article 15, Section 2, 1987 Constitution. Some marriage laws in the Philippines was a common things that are only based on sex and not on gender. Under family code, marriage is defined as special contract of permanent union between a man and a woman entered into in accordance with law for the establishment of conjugal and family life. Article 1, the Family Code of the Philippines. When two person has a special contract of permanent union with accordance with the law for the establishment of the family, if you are married, the things you have, men and women shall be considered as your both property. The fact that the specific law provides marriage only for men and women causes exclusion of homosexual relationships as it only accommodates heterosexual ones. This deprives members of the LGBTQ of this constitutionally enshrined right afforded supposedly to very Filipino. Flowing from that definition, succeeding provisions of martial laws of the Philippines are anchored on the above inequality, as the law provides that marriage only for men and women causes a certain of the exclusion of homosexual affinity because marriage only accommodates heterosexual relationship. Apart from martial laws, various personal laws present this picture of inequality in its provisions. The crime of adultery presents harsher requisites than the crime of concubinage. Article 333 and 334 of the Revised Penal Code. Vagrants and prostitutes pertain only to women. Article 202 1202 of the Revised Penal Code. Gender equality issues on night work prohibition, Article 130 of the Labor Code. Disputable presumptions, Rule 131, Section 3 of the Rules of Court, and removal of criminal liability for rapists under Republic Act 8363 should also be visited. Incorporating gender inequality in various laws are vital to be addressed, as otherwise this concept will further pro-life rated.
The primacy of the decision of the husband father. Under the Article 14 of the Family Code of the Philippines, it is provided that in case either or both of the contracting parties not having been emancipated by a previous marriage are between the ages of 18 and 21, they shall, in addition to the requirements of the preceding articles, exhibit to the local civil register the consent to their marriage of their father, mother, surviving parent or guardian, or persons having legal charge of them. In the order mentioned, such consent shall be manifested in writing by the interested party, who personally appears before the proper local civil register, or in the form of an affidavit made in the presence of two witnesses and attested before any official authorized by law to administer oath. The personal manifestation shall be recorded in both applications for marriage license, and the affidavit, if once is executed instead, shall be attached to said applications. On the administration and enjoyment of the community property or conjugal partnership, Articles 96 and 24 of the Family Code provided that the administration and enjoyment of the community property shall belong to both spouses jointly. In case of disagreement, the husband's decision shall be prevail, subject to recourse to the court by the wife for proper remedy, which must be availed of within 5 years from the date of the contract implementing such decisions. The administration and enjoyment of the conjugal partnership shall belong to both spouses jointly. In case of disagreement, the husband's decision shall prevail, subject to recourse to the court by the wife for proper remedy, which must be availed of within 5 years from the date of the contract implementing such decisions.
On the exercise of the parental authority over the person and legal guardianship over the variety of common children and Article 211 and 225 of the Family Code state that Article 211, the father and the mother shall jointly exercise the parental authority over the person of their common children. In case of disagreement, the father's decision shall be prevail unless there judicial order to the contrary. So, mao ni siya. Akong akong magsabutan sa 211 kay mo nang batas sa mga bata sa mga mo nang batas sa protection sa mga bata nga dili dapat sila magpasakit sa ilang mga ginikanan, mga parents. Mana siya. Article 255 2255 225, the father and the mother shall be legal guardianship over the priority the emancipated common child without the necessity of a court of appointment in case the disagreement. So ang 255 dapat akong giingkon sa akuan lang gid. Ang 255 kay dapat kita mga children dapat mo sunod ta sa mga sugo sa tong ginikanan. Uban pang mga nilang mao lang na siya.
Forgiveness clause in the crime of rape, R8 8353, or the anti-rape law. The anti-rape law RA 353 contains a clause that can easily exonerate the offender and that can further endanger the victim. In the law, it was stated that subsequent valid marriage between the offender and the offended party shall extinguish the criminal action or the penalty imposed. This gives an easy way out for the offender, which in effect does not bar him from committing the crime. Further, it also recognizes that if the offender is the legal husband, the subsequent forgiveness by the wife, who is the offended party, shall extinguish the criminal action or the penalty. This perpetuates violence, the shroud of marriage, which can perpetuate these kinds of abuses for a long period of time. Exclusive definition of prostitution. Article 202 of the Revised Penal Code, amended by Republic Act Number 10158, retained the decade-old definition of prostitutes as women who, for money or profit, habitually engage in sexual intercourse or lascivious conduct. Following this definition, a man who peddles sexual acts for the profit is in effect invisible in the eye of the law, thus making the actor thereof immune to imprisonment. Summary: the Family Code, which contains marital laws and provisions, include provisions which depict gender equality. Legislation on same-sex marriage are good initiatives to address this issue on gender inequality in marital laws. Criminal laws are not different as clearly. Some provisions therein favor the male sex over the female sex. Worse, this pertains to crimes involving penalties for imprisonment.